Ladies and gentlemen, welcome to the People's Law School. This is an effort by the Alabama Association for Justice to bring to you the best lawyers in America. Tonight we have Carol Wallace and Connie Glass. They are going to talk to us tonight about their specialty, which is elder law. I want you to know that they have been pioneers in regard to this area of the law for the last many, many years. Both graduated from the University of Alabama, then later one went to Cumberland, the other went to the University of Alabama Law School. And over the years, they have specialized and become certified in this particular area. By the way, Carol Wallace was the first lawyer certified in the area of elder law in Alabama. I will tell you that when my mother got sick, I brought my mama to them, and I think that's maybe the highest compliment I can pay them. I will also tell you that this program, over the last decade or so, has been the most popular program presented on the People's Law School to the 2 million people of Alabama that see this program every week. By the way, this program is aired in Huntsville at 2 o'clock, 6 o'clock, and 10 o'clock. It's aired out of the Birmingham stations on Wednesday night at 8 and Thursday night at 9. It's aired out of the Montgomery station on Monday at 7 p.m. for your information. But as I said, this program reaches 2 million people, and every time these ladies are on, I get like 50 phone calls that week. But it's my honor and privilege to present to you the elder law firm of Connie Glass and Carol Wallace.
Thank you. Thank you, Alan. We always enjoy coming to the People's Law School. I'm Carol Wallace.
And I'm Connie Glass, and we're partners in the elder law firm of Glass and Wallace.
The field of elder law is really growing. Back when I first started practicing elder law, it really didn't have a name. That was more than 20 years ago. But now there's a national organization called the National Elder Law Foundation that certifies elder law attorneys.
And as Alan told you, we're both certified elder law attorneys. Carol was the first in the state, and I wasn't too far behind her in getting certified as an elder law attorney. To be certified, to go to an attorney that's certified, means you're going to an attorney that has taken a test to be certified in the field of elder law, and each year has to take educational courses to stay up to date in the latest developments. So a certified elder law attorney should know the field of elder law and should be able to keep up with the latest developments.
Yeah, it's kind of like we have to stay in school forever.
Yeah,
that's really
what it
means.
feels like.
We want to talk with you about some issues that it's very likely that will affect all of you at some point in your life. One of the topics we're going to talk about is Medicaid. That's the program that could help pay your nursing home bill.
We want to tell you some of the things that you can avoid if you want the government to help pay your nursing home bill.
Now, some of you may have heard that the rules about how to qualify for Medicaid changed drastically in 2006. These changes were some of the most drastic that we've seen since the Medicaid program started many years ago. And Medicaid's a program that most people in nursing homes in Alabama have to rely on. 3 out of every 4 people in nursing homes in Alabama are on the Medicaid program.
The new Medicaid law, we still call it the new law, even though it was almost 2 years ago now, makes it almost impossible to get Medicaid benefits in the nursing home on your own. Carol's told you, we've each been practicing in the field of elder law almost 20 years apiece, and we see people every day who come in and ask us how to get their family member qualified for Medicaid benefits in the nursing home.
Many people come in the first time and they have talked to a lot of people before they get to us. They've relied on information they got from friends or co-workers or sometimes someone who has gone through the process of putting a loved one into a nursing home. So they think they have some good basic information. But almost always when we start talking to them, we realize that they've gotten wrong advice.
Yeah, we usually try to tell folks just to forget everything they know about Medicaid when they come in. We warn clients that you can't depend on what you've heard from somebody else or what happened to somebody else. You can't really rely on your common sense. You can't rely on your sense of fairness because Medicaid rules just aren't based on either one of those things.
That's right. But do rely on a certified elder law attorney. We'll say that several times tonight, and really what it may come as a surprise to you to know that not all lawyers are trained in Medicaid issues. It's not something that's part of the basic law school curriculum.
Right. So hopefully you'll hear tonight some things about Medicaid laws, especially if you plan to give gifts to your children, to your grandchildren, to charities, or even to your church.
That's right. One part of the law that scares people the most is what happens if you give something away and then have to go to the nursing home. For years, many people have known and heard that if you give something away, there's a period of time that the government wouldn't pay your bill if you went to the nursing home.
In other words, you can't give everything away today and then go in the nursing home and get the government to pay your bill tomorrow. There's a waiting period. Medicaid calls that under their laws a penalty period.
You know, when we talk about a penalty, a lot of people think it's like some kind of dollar fine that you have to pay. But the penalty period that we'll be talking about with Medicaid is a number of months. It's a set period of time where Medicaid would not pay the nursing home bill. Now, one thing that really makes it confusing right now since the law changed is we're still working also with the old law. So right now we've actually got two sets of laws in effect. One set of laws applies if you made a gift or gave something away before February 8th of 2006. And then if you made a gift on February 8th, 2006 or forward, then you're under the new law. So we're still dealing with two sets of rules.
Right. Briefly, if you made a gift or a transfer before February 8th, 2006, then the penalty period, or this waiting period that Medicaid imposed, began running the month after you made the gift. So let me give you an example. If you gave $20,000 away in January of 2006, that created a 5-month penalty period. That penalty period under that law would have run from February of 06, the next month, through June of 06. So if you go to the nursing home right now, that penalty period would have already passed. Doesn't mean anything anymore. Okay?
Right, so that's a good thing. But now let's talk about how that same gift of $20,000 would apply under this new law. If you gave $20,000 away just 2 months later, in March of 2006, then there's still a penalty of 5 months. The difference is when that penalty period starts to run. The penalty period does not begin to run until you are in the nursing home and out of money. Okay? Now you're probably thinking that you heard that wrong.
No, you heard her right. That's the
In
bad
the
part.
nursing home, out of money.
You did hear her right. If you give something away now, after February 8, 06, then Medicaid doesn't impose the penalty period. It sits there like a vulture, just waiting until you're in the nursing home and you're already out of money, and then Medicaid says,
Gotcha.
You don't qualify. Gotcha. You see the problem here, right? How are you going to pay the nursing home bill when you're already there and you don't have any money left?
We're going to give you some more examples about the new law, but let's go back and kind of start at the beginning about the basic Medicaid rules. In order to qualify for Medicaid benefits in a nursing home, the patient has to meet two tests. There's an income test and a resource test.
Right. Let's talk about the income test first. These are the two. The income test is that the patient, the nursing home patient's gross monthly income has to be below $1,911 a month. Just a real odd number.
Yeah, that's a strange number. Now, nursing homes in Alabama cost between $4,000 and $6,000 a month. $1,911, that number you just told them, it is not going to pay a nursing home bill anywhere in the state of Alabama.
But Medicaid says if your income is 1 penny over that $1,911 a month, then you don't meet the income test. The good news is that there is a way to make you meet that income test. You have to go through some red tape. You have to do some extra paperwork. It's called a qualified income trust, and a good elder law attorney can help you set up one of those qualified income trusts.
Now, the timing of setting up this trust is very important. We met with a family recently who their dad had been in the nursing home about 3 months, and they'd applied for Medicaid on their own and gotten a letter from Medicaid saying denied benefits. He was over the income limit. And they came to us really confused. They said, now how could he be over the income limit? Because they had picked up a form at the Medicaid agency and it said qualified income trust. So Medicaid's given out a form. They had filled it out, the dad had signed it, and they'd turned it in. So they thought they'd done everything right.
Right. Medicaid was real helpful to give them the form. However, they didn't know that signing that form was just the first step. The next thing they should have done is taken that form down to a bank, opened a new income trust account, had the dad's income checks deposited into the new income trust account, and then write the checks out of that new income trust account to the nursing home. They hadn't done any of those things, so lo and behold, denied Medicaid benefits because they didn't meet the test.
Right. Now that's the income test, and actually that is the simpler of the two tests.
Yes.
Okay? The resource test or asset test is much more complicated. A resource or an asset is anything that you or your spouse own that you could convert to cash to pay your nursing home bill.
Right. There are two sets of rules that Medicaid has when it comes to these assets or resources. There are rules for single people, and then there's a separate set of rules for married people. But the married people rules only apply if there's one spouse in the nursing home. If both spouses are in the nursing home, then the single people rules apply to assets.
I know that's confusing. Folks, remember there's two
Everybody's
sets
shaking
of
their heads
rules.
already.
Two sets of rules. One for single people, one for married couples. So I think that's one reason for a source of a lot of confusion.
Right.
You may be talking to somebody and relying on their advice and find out they're not even in the same rule book as
Right.
you are. But let's take a closer look at what an asset is. You know, some things are obviously assets. Your home, your bank account, your car, CDs, stocks, bonds, those things that are easily
Obvious things,
identifiable. But Medicaid says some things are assets that you may not think about. One common one is an annuity. Now, an annuity is an insurance product. They're valid estate planning tools, and lots of people own them. But Medicaid says if you can cash that annuity in, then the cash value, the cash that you can get out of that annuity is an asset.
Right. There are some folks, however, that are going around telling seniors that buying an annuity will protect the money in that annuity from the nursing home. And that's just not true. I think the easiest thing to do would give you an example of how an annuity can even keep you from getting on Medicaid.
So often we see an older person who, it oftentimes happens when they've got a CD that's maturing, and someone sells them annuity, and the selling point is that the annuity will earn more interest than that CD. But what they often don't tell them, or either the older person doesn't remember it, is that it locks that money up for a period of time, sometimes as long as 7 to 10 years. And if you need that money back, there's a pretty substantial surrender charge.
Right. Now, that's not a problem if you don't need the money. You can just sit there and draw interest, right? But if you go to a nursing home, you're probably going to need the money out of that annuity to pay your bill. So, problem then is you're going to have to surrender that annuity, possibly pay a surrender charge, possibly pay some income tax on the interest it's earned, and then with what's left of the money, you're going to have to pay the nursing home.
Right.
So you can see that didn't protect anything from the nursing home buying
Right.
an annuity.
So the take-home message is annuities don't work for protecting money from the nursing home. Don't buy an annuity for that purpose. It just doesn't work.
Well, tell them about what happens, Carol, if you buy an annuity now that can't be cashed in.
Oh, we haven't, I'm not sure I've seen this yet, but Medicaid actually has a rule. There are some annuities you can buy that you can't cash in. They're not that common, but you can buy an annuity that says you cannot cash it in. Medicaid now says if you buy one of those annuities, guess who you have to name as the beneficiary on the annuity? Medicaid.
Good guess.
So that if you die before you get all your money back from it, Medicaid gets what's left.
Right. Another asset that people overlook is savings bonds. The cash value of a savings bond is counted as an asset by Medicaid, whatever you can cash that savings bond in for. Recently, we met with a family whose mom was in the nursing home, and she had been denied Medicaid benefits because she had too many assets. That was what the denial notice said. So they came to us to see what the problem was.
They were confused once again about what could be the real cause of the denial, because she had one bank account, a little checking account, had $1,500 in it. And they had been told she could have up to $2,000. So they thought, well, she's under the resource limit, what could it be? But when we looked through all their papers, we found that savings bond, and we discovered that it had a cash value. It was worth $7,500.
Right, the face was 5.
The face value was 5, but when it had continued to earn interest even after it had matured, so its value today was $7,500. So that was more than Medicaid would allow them to have.
Right, she had bought that $5,000 bond to pay for her funeral and burial, but not knowing it had grown. And the family didn't have any idea it had grown to that much. They had no, it's worth $5,000. They thought that's what it was worth. And they'd been told you could have $5,000 for funeral and burial, thought they were okay. But we were able to get it cashed in, get the money spent on the nursing home, prepaying the funeral and burial, and get her on Medicaid. So this had a good result in the end.
Well, talking about that example leads to another area of a lot of confusion in Medicaid, and that is funeral and burial expenses. Almost all of our clients want to know when they've got to spend down that money, they want to go, gee, can we go ahead and prepay Mom's funeral and burial? And you'd think there'd be a simple answer to that, wouldn't you? I mean, how complicated can funeral expenses be? But it's Medicaid, and there is no simple answer. You start with the general rule that yes, you can prepay some or have some money set aside for burial.
Right, and you can set aside money in a special account for funeral and burial. You can do it a couple other different ways too. You can actually go prepay at the funeral home and the cemetery for the things that you need.
A lot of people are hesitant to do that because they may want to be buried in some place that's not local, so they don't want to go to the funeral home. So Medicaid allows you to actually take some cash, up to $5,000, and put it in a bank account that you've designated, and it actually says on the bank account that it's for funeral or burial expenses.
Right. Or you can have life insurance or burial insurance.
You can have a combination of those. So you can see right there it gets kind of complicated.
But whatever one of these methods you use, if you have more than Medicaid allows, then they're going to deny you benefits because you have excess funeral and burial.
Right. Let's look at an example where burial was the problem. A man was in the nursing home and his family had applied for Medicaid, again without an elder law attorney, and he was denied benefits because of burial, and they came to us.
We looked into their situation and we found out that this gentleman had 6 small funeral and burial policies. I bet you half a dozen of you in this audience, if not more of you, have those same little bitty $500 policies. He had 6 of them. And he had them for years and they were all paid up.
And when he went to the nursing home, he had a little cash left in his checking account, and you know the family was getting down to that magic number of $2,000. So somebody told him, oh, you can go down to the funeral home and prearrange and pay for his burial. So that's what they did. They spent the rest of his money in his checking account fully paying for his burial.
Right. Now, the problem here was that this gentleman couldn't have a fully prepaid funeral and burial and these insurance policies. In some situations you can, but this particular situation put him over the limit.
Right.
So the thing to remember is that funeral and burial rules in Medicaid are really very complicated. They're not just a simple yes you can have it or yes you can't. So you really need to get advice about what's allowed by Medicaid on funeral and burial.
I bet they're thinking right now, does Medicaid allow you to keep anything?
I know I am.
The answer is yes, it's not much, but whether you're single or married, you get to keep a car, some personal items, and that's really the clothes on your back, your wedding ring, and a little furniture, and up to $2,000, and those magic burial funds.
Yeah.
Those are called excluded assets.
In addition to those excluded assets, Carol, of course, mentioned the $2,000 that you get to keep in an account. But if you have more than that, then you've got to spend down any money you have or assets that you have in excess of that before the government will help pay your nursing home bill.
That spend down, that's a phrase that's used throughout Medicaid law, and a lot of times it's kind of hard to say. You've got to wrap your tongue around that D, and a lot of times people don't understand what we mean when we say spend down. And it's strictly taking the assets or the money that belongs to the patient and using them for the patient's needs, mostly nursing home expenses, until their money is spent down to below $2,000. That's spend down.
Now, contrary to what some folks believe, spending down is not paying the down payment on your daughter's new house or sending your grandson to college, paying his tuition. That's not spend down.
Or buying that fancy car for a grandson.
No, that's not spend down. For married couples, the amount that they have to spend down is really a lot harder than it is for single people. For single people, it's everything in excess of $2,000, but it's much harder because, remember earlier we told you there's a different set of rules for married couples?
The first big difference in the rules for married couples is that when you got a married couple and one spouse is in the nursing home and one is at home, the good news is that the couple gets to keep their home place as long as one spouse lives there. In addition to the home, Medicaid allows that one at home to keep a portion of the other assets. There's a magic formula they use.
Yes, another formula. This formula is applied and is based on the assets that the couple owns when one of them goes to the nursing home. And basically, the spouse at home, the one not in the nursing home, gets to keep 1/2 of the non-excluded assets that the couple has. But it's not always half. There's an upper limit and there's a lower limit.
Okay, I think the easiest way maybe to understand this is to give you 3 examples to show how different the results can be. Let's look at a couple that we're going to call Harry and Barbara. And we're going to put Harry in the nursing home.
Of course.
We always put our men in the nursing home. So
Ladies, is that fair?
they have a home and they have $25,000 in cash in the bank. That's all the countable assets that they have. So they come to see us and we are able to give them really good news. Barbara is going to get to keep the home and the entire $25,000. We can get Harry on Medicaid immediately without having to spend anything.
Right. Let's look at another couple, Bill and Sue. They've got a home, but they have $300,000 in assets when Bill goes to the nursing home. Again, we're going to put our gentleman there. Well, Sue will get to keep the home, but she'll only get to keep a little over $100,000 because that's that upper limit we talked about. Medicaid says that the rest of the money, almost $200,000, will have to be spent on Bill on his needs in the nursing home before he can get on Medicaid benefits in the nursing home.
Right, that's a big difference. See, the wife there didn't get to even keep half. But let's say that Bill and Sue, instead of having $300,000, they had a house and $100,000. In that case, Sue, the wife at home, would get to keep half. She'd get to keep $50,000, and $50,000 would have to be spent on Harry's nursing home care. So it's a drastically different result in every case.
Right. Now, we obviously don't expect you to remember all these numbers. And
We don't. I thought we were going to give them a test.
A test at the end, sorry. Because these numbers actually change year to year, so it wouldn't do you any good to remember them right now. But the important thing to remember is that there's never one answer to what couples get to keep. It's not the same from couple to couple when one goes in the nursing home. It all depends on what the couple has when one goes into the nursing home.
I think that's probably one of the most common mistakes that we see people make, and we can understand why, because if you're talking to somebody and you know you're married and your spouse is in the nursing home and you're talking to somebody who's in the exact same situation, one spouse at home, one in the nursing home, common sense would make you think that you could rely on advice about what happened to them, but you can't. Every single couple's situation is different.
Right. You really can't believe a lot of what people tell you, and they're really well-intentioned when they do it, when they want to share with you advice, because they know, you know, what happened. But there's still a real common misconception out there that people believe that if one spouse goes to a nursing home, a magic way to protect everything is to put it in the other spouse's name, and then it's all protected. Not true.
Not true. But you know, want to know what is true? For married couples where one's at home and one's in the nursing home, Medicaid looks at all assets in either spouse's name. It does not matter which spouse owns the asset. And this is true when it's a first marriage, a second marriage, or a 10th marriage. It just doesn't matter. Medicaid counts everything that you and your current spouse own.
In fact, Medicaid doesn't even care if the couple's living together.
Right,
If
right.
you're married, you're married. It counts. Another thing I want to point out is that Alabama is one of the few states left that still recognizes common law marriage, so a lot of folks may be more married than they think they are. So.
Oh, that may be scary. Medicaid also doesn't care if you have a prenuptial agreement saying that you won't be responsible for each other's nursing home bills. A lot of people in second or subsequent marriages are doing prenuptial agreements, but Medicaid just doesn't honor those. So if you're married, all of the assets that you own are accountable to the other spouse, even if you have a prenuptial agreement.
That always makes me think about a case that we had when we first opened our practice back in '97. A really nice, sweet lady came to see us, and her husband had just gone to the nursing home. The sad thing about that was they had only been married a month, and he had had a stroke on their honeymoon.
And they thought they had done everything right. They both had children from their previous marriages, so they wanted to protect what they had for their own sets of children. So they had gone to an attorney, and they had agreed to keep everything separate, and they had done that prenuptial agreement before they married.
Right. She had a very comfortable estate. She had about $250,000 that her first husband and she had accumulated. She was comfortable. The man that she had married was not so comfortable. He and his wife had some financial difficulties, so he had a very small estate.
So she came to us really just to help do the application, because she felt very confident that he was going to qualify right away because he didn't have any money. But we had to tell her the bad news that he would not qualify for Medicaid because of her assets. And even further, that what they had put down in their prenuptial agreement meant absolutely nothing to Medicaid.
Right. Bad result. One of the common questions that we get, one of the most common questions is, do I have to spend everything on the nursing home? Is there not any way to protect anything? Can I give something away? Well, this new law that we keep talking about has made it so much harder to protect assets from the nursing home.
When you give something away, whether it's your home or cash, anything of value, Medicaid calls that a transfer. You may call it a donation to charity or a gift, but Medicaid calls it a transfer. And when you apply for Medicaid benefits under that old law before 2006, if you filled out a Medicaid application, you actually had to report anything that you had given away in the last 3 years. That 3 years was called the look-back period.
That look-back period has now been extended to 5 years. So right now, if you apply for Medicaid, that means that Medicaid can look back in your financial history to see what you've given away in the last 5 years. Well, maybe you're thinking, well, that's not so bad.
Well, one problem with that is that a lot of folks are not great record keepers.
No.
Yeah, a lot of our clients throw bank statements away and cancel checks after about a year, some of them after about a month. And a lot of people don't keep records of where they've closed bank accounts or cashed CDs or cashed or sold bonds or stock or any kind of finances. So it becomes very difficult to create that paper trail. And after a number of years, sometimes it's very hard and even impossible to go back to a bank and get copies of all of those transactions.
We won't ask for a show of hands as to how many of y'all do that. The problem is when you apply for Medicaid, the responsibility is yours to provide the records that they need. Medicaid doesn't have to take your word for anything. You have to back it up with the paperwork. They've got to have it in writing. So if you can't provide records that they're asking for, then you could really qualify for benefits and be denied just because you can't give them the records that they're asking for.
And here's an even bigger problem why the 5-year waiting period is so serious. None of us have a crystal ball. You know, we don't know what's going to happen to us next week, much less 5 years from now. And under the new law, what you do with your money today can actually affect what kind of care you receive in a nursing home more than 5 years from now.
That's because of that problem that we mentioned earlier at the very beginning. That law in 2006 changed when the penalty period began to run. Remember what we said, that can keep Medicaid from paying your nursing home bill for years.
For years. A couple came to us a few months ago about the wife's mother. She had lived alone for a long time in her own home, but she had started falling a lot, and they had really gotten concerned about her safety and decided that she could not live alone anymore.
Right. The mom sold her home for $80,000. She moved in with the daughter. She took $50,000 of her money, and she added an addition onto the daughter's home. That was going to work out great. Mom would have her privacy, daughter would have her privacy, but still be able to look in on mom.
Well, the mother was able to live with the family for about a year, but then she had a very serious stroke and needed round-the-clock care. But the daughter still had to work, so they took what little money the mother had left from selling her home, and they hired caregivers round the clock. But when they ran out of money, they really didn't have a choice but to place her in a nursing home.
So Mom had no more money left. They filled out the Medicaid application. Of course, they put down about the $50,000 because they honestly believed that was for Mom. They didn't think
Right.
that was going to be any problem.
Right.
It was for Mother's benefit.
Yeah, but Medicaid said that $50,000 that this family had used to build on that room for Mom in their own home was a transfer. So that kept her from getting her nursing home bill paid by Medicaid for 14 months.
So in this case, the family had to make a choice. They either had to come up with 14 months of nursing home bills, or they were going to have to bring Mom back to the house and take care of her full time.
There are many other people who are being hurt by the new Medicaid laws, and not because they've given anything away, but because they pay with everything with cash. We see this a lot. Older people don't like to write checks. It's inconvenient for a lot of them, so they may cash all of their income checks and use it to pay for everything during the month: gas, groceries, medicines, whatever they need.
Right.
And so the problem is, if they apply for Medicaid, a lot of times there's no bank records to prove at all what they've done with their money.
And Medicaid can count those cash withdrawals, those undocumented withdrawals, as transfers and can apply a penalty for those transfers. If a person takes out $1,000 a month over a period of 5 years, that's $60,000 in transfers. And remember, that penalty period for that transfer is not going to be applied to the person's in the nursing home, already out of money.
Right. We recently had a client who had moved in with her daughter after she had a stroke. She had some paralysis, so the daughter did most of her shopping. And then, I bet you can guess, Mom takes out her checkbook and writes a check to the daughter to pay her back.
Well, lady ended up having to go to the nursing home. The daughter spent what little money her mother had left, applied for Medicaid. Guess what happened? Medicaid asked for bank records.
Well, the daughter honestly explained what had happened. She said, well, I do all Mom's shopping, and so Mom periodically pays me back. And the daughter didn't have all the receipts. She produced what she could, but most people don't keep all the receipts. So Medicaid is taking the position in these kinds of cases that when you don't have a receipt to show what you're reimbursing family members for, they're just saying it was a transfer.
So, we think that the lesson that we're supposed to learn from this is if you plan to go to the nursing home in the next 5 years, keep every check, every receipt that you could possibly need for that Medicaid application.
It makes you wonder if it's even going to come to where we need to take a photocopy of it, because, you know, ink on receipts doesn't last very long. It starts fading.
Yeah.
So that's a very, very harsh
Photocopy all those
rule.
receipts and keep them in a file folder in case Medicaid might ask for them. All right, enough negative for the moment. Let's shift gears a little bit and talk about something a little more positive. I'm going to take a break. I'm going to leave Carol up here alone for a little while, and she's going to talk about how planning can be done for children with disabilities, some real positive things. And then she's going to switch gears a little bit and talk about guardians and conservators.
Okay, thanks, Connie. What would you do if you had to place your wife in a nursing home and then you still had to care for your 40-year-old son with Down syndrome who still lived with you? That's the situation that faced one of our clients recently. He came to see us right after he had placed his wife in the nursing home, and he was very overwhelmed and concerned that when he found out that the nursing home was going to cost about $5,000 a month, he saw the nest egg that they had worked so hard to save for their child evaporating. He was so afraid that they were going to have to spend everything on the wife's nursing home expenses and not be able to leave anything for this son after they were gone. The couple had a home and they had accumulated about $250,000 in cash assets. So without any planning, what we told I'll call him Mr. Black, is that he would have been able to keep the home and a little over $100,000. But the rest of it, about $150,000, would have to be used on Mrs. Black's care in the nursing home before she could qualify. But because this couple had a child with a disability, we were able to give them some good news. Under Medicaid rules, you can actually create a supplemental needs trust for the child with a disability, and we were able to move the entire amount of money that would have had to be spent on Mrs. Black and put it in that supplemental needs trust. So we took their $150,000, put it in a trust for this child, and got the mother qualified for Medicaid right away. They didn't have to spend any of their life savings on the nursing home. Now, to complete the planning for this family, we took an important second step, because if Mr. Black had died first, the way they had everything set up was the home and everything that had been set aside for him would go right back to his wife. So that wouldn't have really helped that much. So we got the home and his money in his name and did a new will for him that said, when I die, everything that I've got also goes into this special needs trust for their son. So ultimately, we were able to protect everything that that couple have. Now, when you have a trust, one of the first things this gentleman asked us was, well, who's going to manage that money in the trust when I'm no longer here? So you have to name a trustee for a trust. In this particular case, there was another child, adult child, who stepped forward and said, well, I'll be glad to be the trustee. But we see a lot of families who don't have a family member who is qualified or willing to serve as trustee. But there's an answer even for those folks. In Alabama now, we have an Alabama Family Trust. It's really a public trust that was created by our Alabama legislature to allow families to place money into a trust for a disabled person. And the trust is managed and operated by a board of directors. Actually, Regions Bank is our co-trustee, and they invest the money and pay the bills out so that the money can be used for the benefit of the disabled person. Another area that we as elder law attorneys deal with every day is guardianships and conservatorships. So I want to tell you just a little bit about those. We only do this as a last resort. What we hope is that most people will sign a durable power of attorney, and Connie's going to be talking with you a little bit about that in just a moment. But for people who have not planned ahead, sometimes it's necessary to go to court and have someone appointed as the guardian and conservator of that person. The purpose of a guardian and a conservator, the roles are different, so let's look at them separately. A guardian is a person that's appointed by a court to make personal decisions for someone who's incapacitated. It's kind of like a parent over a child. The guardian is responsible for deciding where the incapacitated person lives and what kind of medical care they receive. The conservator is the person that's appointed by the court to manage the person's assets, their money or their property. So they have to pay the bills and handle the assets. Sometimes the guardian and conservator is the same person. It certainly can be, but sometimes it's different. It is possible, we see it sometimes where an incapacitated person doesn't have a family member who is willing to step forward and be appointed as guardian and conservator. And luckily, anyone who is an interested person can file a petition for guardianship without being appointed themselves. We saw this recently when a lady who had lived in our area for a long time became incapacitated. She was a widow and her only child had died. She had lived in the same home for about 30 years, and it was one of those neighborhoods where it was very stable and people had lived there for a long time. Several of her neighbors came to see us, and they said, well, after her son died, she just became very reclusive and really didn't socialize much. So the neighbors would periodically take groceries over there or take meals and try to get invited inside so they could see if she needed any help. And they said lately they'd noticed that she wasn't bathing regularly, and mail was all piled up on the kitchen table, and there was old food in the refrigerator. So they said, we just don't want to interfere and we don't want to offend her. What can we do? So these neighbors were willing to actually file the petition with our help, saying that this lady was incapacitated and needed a guardian, but they didn't want to be appointed with that responsibility. So in those cases, the probate judge can appoint what's called a public guardian and conservator. It's usually a local attorney who takes on that responsibility. In this particular case, it worked out just great because once the guardian was appointed, they had access to her finances to see what she had. She had plenty of money available to pay caregivers to come in and help her with those daily things in her shopping, everything she needed. So up to now, she's been able to stay at home and be safe. Now, if she keeps declining it would become the guardian's responsibility to make other arrangements for her. The guardian in this case with the public guardianship also was the conservator, so he was managing the money for her as well. With guardians and conservators, there are some pros and cons. As I said, it's usually kind of a last resort, so it's something that you don't want to just jump into without thinking it through. One of the positive things is that once you are in court, the person that's being appointed has to be bonded as the conservator, and they have to file a detailed accounting with the court of all of the assets that they'll be managing. They actually have to go back to court periodically, at least every 3 years, but a judge may say as often as every 1 year, to show the judge everything that you've done with every penny of that person's money. So there's some financial protections in place. A guardianship and conservatorship also sets out clear decision-making roles. There's no doubt about who's in charge once a guardian and conservator is appointed. And although this sounds negative, it can be positive. A guardian and conservator takes away, once that is appointed, takes away the power the person has to act for themselves. Only the guardian or the conservator can legally act for them at that point. Now, some of the negative things that you need to think about with a guardian and conservator is there are some costs involved. You generally have to have attorneys to go to court, and there are some court fees and the premiums of the bond and those annual accountings. So there are continuing court costs. So if you have someone who has a very small estate, the family can become very concerned about trying to stretch that money out for as long as possible to take care of the person. So the cost can become a factor. Also, guardianships and conservatorships are actually, it's a court case, so it puts on public record that your loved one is incapacitated. And the incapacitated person must be notified of the hearing. It's not something that you can do in secret behind their back. So for someone who still has some capacity, it can be very uncomfortable for family members sitting right beside Mama testifying about what types of problems that she's having. Now Connie's going to come back up here, and I'm going to take a break, and she's going to come talk to you about some estate planning issues.
All right, thanks, Carol. One of the main areas in our practice of elder law is estate planning. Everybody always asks, what's estate? What is an estate? What does estate planning mean? What is that, you hear that term, what does that really mean? It means that you're planning ahead. You're planning ahead for some period of time when in the future that you might not be able to manage for yourself, or after you're gone. What's going to happen to your things and the things you've accumulated during your lifetime after you're gone. There's lots of ways to do an estate plan. There are wills, there's trusts, there's numerous kinds of trusts, and time doesn't allow us to go into all of those tonight. So I just want to give you some of the basics of a good estate plan. But know that you need to get with your attorney and decide what's the right thing for you, because you may want to have more than just these basic things that I want to talk about tonight. We think there are 4 basic documents that everybody ought to have. The will, a durable power of attorney for finances, a durable power of attorney for health care, and an advance directive. Most of you probably have heard that called the living will, and I want to run through all 4 of those tonight real briefly. The will. You're going to have a will. Either you're going to write it or the state of Alabama has already written it for you. The state of Alabama has laws called the laws of intestacy. And if you choose not to write a will for yourself, then the legislature's written one for you directing who's going to be in charge of your estate, where your assets are going. And I can almost guarantee you that it's probably not who you want to be in charge and not where your assets will ultimately end up where you want them to be. So if you want to have some control or some decision making about where your assets go and how they get there and who's in charge of them after you're gone, the only way you can do that, the basic way you can do that is through a will. Of course, there's other ways through a trust, but the basic way is through a will. One of the big issues that we see, though, is people have these beautifully drafted wills and they're not worth the paper they're written on. And I know you're thinking, well, what in the world could she mean by that? What happens is you have a will that says one thing, but you've done planning otherwise in the way that you own your assets to leave your assets another way. Let me give you an example of how that can happen. This is a common situation that we see all the time. Let's say there's a widow, she has 3 children, and she comes to us and she wants to write a will that leaves all of her assets equally to her 3 children. Okay? Common scenario. Well, when we draft a will for somebody, we ask them to bring in a lot of financial documentation that we can look at. Deeds, copies of bank records. We want to look at everything that she has. And it's not uncommon for us to say, well, we can write you a will that says that, but that will won't mean anything. Because what this lady may have done is to add one child's name to all of her assets for convenience, she thinks. Because she might have a daughter who lives next door to her, and that daughter's the one that takes her to the doctor and helps write the checks and pay the bills and does everything for her and helps her. So she puts that daughter's name on everything, not realizing that after she's gone, all of those assets will belong to the daughter, because the daughter is the named owner of those assets. Now, it's not uncommon for her to say, well, you know, she'll do the right thing. She'll divide that with her brother and sister. And she might. She might not. So, you know, if you don't want to leave that to chance, then you don't need to add one person's name as the owner of your assets and then have a will that says divide it 3 ways when that will may not mean a thing after you're gone. So it's real important when you have a will that you make sure that the ownership of your assets and the beneficiary designations are consistent with how you have your will drafted. Because if you have a will that says one thing and ownership that says another, the ownership is going to trump that will. Ownership will control. Okay? The next document that we believe that's important for you to have is a durable power of attorney for finances. Durable is not magic. Durable just means that there's special language included in the power of attorney that will allow that power of attorney to be used even if you become incapacitated. There's some special wording that's included. That's all that durable means. But the durable power of attorney allows you to appoint an agent or somebody to be in charge to make decisions for you regarding your business and your finances should you not be able to do that for yourself. A lot of folks believe that when you write a will and you name what a lot of people call an executor, or the law now calls a personal representative in your will, that that person can take over if you should become incapacitated. But if you don't hear anything else I say about estate planning, listen. The will only takes effect when you die. The person you've appointed in the will doesn't take over if you're sick. That's the power of attorney. Will when you're dead. Power of attorney when you're sick. Okay? So naming one doesn't mean you have the other one. If you have a power of attorney, you don't have a will. If you have a will, you don't have a power of attorney. You got to have both to cover you both during lifetime and at your death. It's always real important, too, in a power of attorney to name an alternate, because the first person you name, they could become ill or pass away before you. It's always a good idea to have at least one alternate in a power of attorney, and you'd be surprised how many powers of attorney we see that don't name alternates. A lot of folks go and they name their spouse, not thinking, what if your spouse dies before you do? Then you don't have anybody as power of attorney. And if you become sick, nobody has the ability to step in to take care of you. And I know some of you are thinking, why in the world would I want to give my spouse power of attorney? Doesn't my spouse have the right to make decisions for me? Well, there's certain things your spouse can decide for you. You know, what kind of tie you wear to church on Sunday, and, you know, what you're going to have for dinner tomorrow night. But your spouse does not have the ability to sign legal documents for you. And this was brought home real recently to one of our clients. It was a real sweet lady who came in. Her husband had gone to the nursing home, and most of their assets were in his 401k, and she needed to access that money to pay the nursing home bill. She had no ability to access that 401k. Well, she said, I'm the named beneficiary. She gets it after he's gone, not while he's living. So remember Carol talking about guardianship, conservatorship? That's what we had to do for her. We had to go to court and get her appointed guardian and conservator just so that she could get the money out of his 401k to pay his nursing home bill. They had never bothered to go do powers of attorney to each other so that if one of them got sick, the other one had the ability to access those funds. The third document I mentioned was a durable power of attorney for health care. That can be combined with a financial power, but in Alabama, listen to this, a power of attorney must include language that it has health powers. If it doesn't say that, you don't have health care decision making. So if you have a very old power of attorney, it may not have that language in there that says that somebody can make medical decisions for you. So be sure that if you've got a power of attorney that you look at it and it says that they can make medical decisions. If it doesn't say that, they can't. So there may be a situation where someone needs to make medical decisions for you and there's no ability to do that. That leads me to the last document, which is the Advanced Directive for Health Care. Probably all of you have heard of this. It's the living will. They've done all kinds of studies. Most everybody agrees that they need a living will, but most everybody doesn't have one. They're such easy documents to get. You don't need Carol and me to even do one for you. We'll be happy to, but you can get these just about anywhere. You can get them at the hospital. You can get them at a senior center. You can get them on the Alabama State Bar website. They're so readily available, there's not a reason in the world that all of us shouldn't have a living will. And a living will doesn't mean it's a dying document. You can choose in your living will that you want to be kept alive. If it's important to you that they keep you alive to try everything possible, you can choose that in your living will. But if you have strong feelings either way, either you want to be allowed to die naturally or you want to be kept alive, then you need to put that in writing in your living will. It doesn't have to be notarized. It has to be witnessed by two people not related to you by blood or marriage. And you need to be sure that your doctor and your closest family members have a copy so that if that need should arise in an unexpected crisis situation, that everybody knows what you want done. It's not something you need to hide under the bushel. You need to get it out of that drawer, and make sure that everybody knows that you have it, and keep it up to date, and make sure that everybody that's closest to you that might be called upon to make decisions has that document in hand. Okay? Those are just some of the real basic things that you need to do for an estate plan. I could go on, but you don't want to listen to me for a few more hours talking about estate planning. Don't do just one of these. Do all of this. And you may need to do more depending on your particular situation. You get to a good attorney and you decide for yourself what you need in your own estate plan with the help of your attorney. But don't do partial planning. Partial planning is bad planning. It's just not good planning. So do complete planning when you do an estate plan. All right, if Carol will come on back up and join me, then we'll get finished up, get y'all going, get out of here.
All right, we've talked about elder law a lot tonight, and why is elder law such a unique area of the law? You know, there's not many of us. We're kind of a rare breed. Elder law is the only area of law that's defined by the people who need us, not the types of cases that we handle.
And Carol and I got into elder law because we think that it's important to help people with things that happen in ordinary life. The things we do are things that apply to everybody in this room and everybody that's listening to this. It's things like doing wills, doing an estate plan, guardianship, planning for children with disabilities, settling somebody's estate, helping get somebody in the nursing home on Medicaid.
Yeah, chances are pretty great that at some time in your life you're going to need an elder law attorney. You're going to either have a spouse who needs nursing home care, or your dad may get Alzheimer's, or you may be appointed as the personal representative in a will and need help settling an estate.
We want to finish up tonight, as we always do, by reading the poem Warning by Jenny Joseph. This has kind of become our trademark poem, and we'd like to share it with you.
Poem. When I'm an old woman, I shall wear purple, with a red hat which doesn't go and doesn't suit me. And I shall spend my pension on brandy and summer gloves, and satin sandals, and say, we've no money for butter.
I shall sit down on the pavement when I'm tired, and gobble up samples in shops, and press alarm bells, and run my stick along the public railings, and make up for the sobriety of my youth.
I shall go out in my slippers in the rain, and pick the flowers in other people's gardens, and learn to spit.
You can wear terrible shirts and grow more fat, and eat 3 pounds of sausages at a go, or only bread and pickles for a week, and hoard pens and pencils and beer mats and things in boxes.
But for now, we must have clothes that keep us dry and pay our rent and not swear in the street and set a good example for the children. We must have friends to dinner and read the papers.
But maybe I ought to practice a little now, so people who know me are not too shocked and surprised when suddenly I am old and start to wear purple.
Thank y'all very much.